the way our laws are made. And in the case of the Public Order Act, the parliamentarians, together with a simple majority, said that the Public Order Act in its entirety is hereby deleted. Just one sentence can take care of this problem. So it is for all of us to demand from our parliamentarians laws that are not only empowering, but in their application are tending towards justice. So really trying to do a lawyering, which I see a lot of activists do, starting with the GPU. They spend so much time trying to see how their lawyering skills are, because some of them ended up becoming lawyers. So instead of wholesale changing the way we make laws, especially where human rights are concerned, that you don't have clawback provisions or you don't have provisions that limit the enjoyment of those rights. This is where Parliament could really have a transformational role in this transition that we are going through. I thought I would just add that to the conversation.
Good afternoon to the distinguished high table. My profound lecturer, Professor Fanding. It's a great pleasure to learn this afternoon that both Dr. Almamy Taal and Dr. Taal are not mere legal women, but they are also great historians. And I keenly follow your deliberations while I was on the coming, and also this Dr. Taal. And from Dr. Taal analysis that led to the collapse of the draft convention 2000 and 2004 respectively was political will and personalization. And again, while he was speaking, my historical mind was running over the past failed institutional reform commissions and other policies that have been instituted. This gave me the impression that, or the opinion that, perhaps as institutions have legal representatives, I want to ask this question. From your historical minded level, or perhaps us, don't you think that some of these problems could have been remedied if each of these institutions have a historian in their midst to be guided historically on policy formulations, law implementation, and others, based on the fact that, or backed by the point that the eminent English historian E.H. Carr persisted that history is the light of the past in which we see the future or the present. If that is the case, having a historian, don't you think, will be able to remedy it, and perhaps they could have advised them on past failures or past discrepancies that would have been a very good guide for us having something that will serve national interest in the state of personal interest.
The job of a historian is to write history. If you are part of an institution, the difficulty is that you may want to write the story of that institution, like Achebe has alluded to. Governance and leadership in our time is a highly political process. What we need to do is, as citizens, engage with our elected representative, because Abraham Lincoln famously said that government by the people, for the people, and of the people is the real definition of democracy. So whether you are a lawyer or a historian or a chemist, your responsibility when you are elected to office or once you are asked to lead an institution, is to, of course, go and talk to good historians and have them as your advisors. And also find out about history on your own, because that also can help, because then you would have the benefit of hearing from a historian lawyer. Also, you can hear from a poet lawyer. You can hear from a diversity. Leadership is really the crisis of our time. We have people in offices who really spend almost all their time trying to do trivia or gossip. This is the serious situation in the Gambia. So those of us at university or call ourselves public intellectuals, we have a responsibility to organize events like this, occasions like this, as regularly as possible, so that we can learn from each other, so that we can amplify the space between the governed and the governors. We need to talk to each other. It doesn't really matter whether every institution will have a resident historian or a resident lawyer. It matters, however, that the broad canvas of our constitution moves towards justice.
Senior Counsel answer that question effectively.
I think we have to rethink our education system, because we are not teaching history in our primary schools and in our upper basic schools. And in our high schools, history is only for art students. And even that is not compulsory. And the people without historical knowledge of themselves, it's a problem. If you go to the United States, they start teaching their kids about their constitution, about their history. Every American child knows the American basics about the American constitution. Elsewhere in Nigeria, the Historical Society of Nigeria has fought very hard for history to be returned in the curriculum. Now in Nigeria, from primary 1 to grade 12, history is compulsory. So probably we need to have a very robust debate on that. See,
in operation, I think is a relic of the colonial era, and it speaks to the way we define fundamental human rights in the Gambia. If you are familiar with the American Constitution, they draft, well, maybe because of the history, but they drafted their laws, especially their Bill of Rights. They said that the Congress cannot make any law to abridge these basic rights: religious freedom, expression of self-expression, expression of opinion, the right to assemble peacefully. But they went in an